Hello again. This is Bill Henshaw, a big troublemaker here, and another current event that you might have taken some notice of, which is that a San Francisco 49er football player, Reuben Foster, recently, and he was one of the lucky ones, by the way, got out of charges of domestic violence when it was proven that the complaining party not only committed perjury about what happened or did not happen, as the case may be, she apparently had a history of doing this. Now, this type of situation, and you think the government has the burden of proof here beyond a reasonable doubt. So, to you advocates of the Me Too system here, you got to realize this kind of a charge isn't a he said, she said type of case. With that kind of burden beyond a reasonable doubt, in my view, you're going to have a lot of relevant, admissible evidence from Abby Shuto in order to go into a case like that and expect to get a reasonable conviction, because the system is already geared astonishingly against criminal defendants. In fact, I'm just reading an article recently I'm going to talk more about at another time, that especially with poor, indigent defendants, which of course Reuben Foster wasn't one, but my gosh, the figures there were that only 1% of felony cases go to trial for people like that. Most of them end up, taking plea bargains to get lesser time, when for the most part they might have not done anything at all. And this is especially true in domestic violence cases. And I do have something of a little history with this during my vacation in that jail cell in Columbia, South Carolina, because I had a lot of people that came to me for help when the word got around that I was someone that knew what the hell I was doing. And a lot of them were in there charged with domestic abuse, and all of them were charged with first degree felony domestic violence. Every one I saw was charged with that, and yet the facts from what I could gather, and yes, that's true, I only heard, the side of the story from the prisoners, not the victim. But some of the papers I was able to read, and this, that, and the other, convinced me that these could not all have been first degree domestic violence, and they got a high bail set on them because of that. Kind of a funny note about that, I was in there charged with a felony for practicing law without a license. And as I told the judge the first court appearance I made, I don't practice it. I get it right the first time. But I'm there and I'm sitting there on a $10,000 bail, and I told the quote unquote judge at the time, might as well be a million because I don't have it, you can't define it, and I can't pay it. That said, I had people in there on felony, domestic violence. Their bail was $35, $40, $50,000, so they can't get out. They just can't, and they're sitting there on charges that they have no business being charged with, except that the prosecutor, and trust me, this is especially true in South Carolina, they overcharge, which apparently the Supreme Court says you're allowed to do, and they have immunity from your subsequent civil rights lawsuits. I mean, they don't give a damn. All they want to do is charge enough felonies to be sure that they get a plea bargain and keep their 98% conviction record. So how much help I ended up doing there, I don't know in the long term, but I would sit people down and talk to them off the top of my head, write down cases and say, get this to your public pretender and get them to do their damn jobs. And as a result of that, by the way, I'm pretty sure the people happiest to see me leave out of there was the office of the public pretender. They actually have to start doing their damn jobs. But this is the kind of thing you get with domestic violence, and that's why the burden of proof is so high, and it should be equally high when the prosecutor charges crimes. That to me, and may not violate any quote unquote civil rights, but it sure as hell does violate it, especially when I can prove that the court won't have jurisdiction in any event. That's a case I would love to be able to take on for that kind of abuse. But they don't have any criminal jurisdiction, none. It took them 7 months to figure it out in Columbia. In my case, hopefully they'll be paying me for that the rest of my life. But this has got to stop. I mean, my goodness, if you don't have the proof, it's he said, she said, not how it goes. It certainly isn't how it goes for a rape case either. You've got to have hard evidence that you can present and prove that the perpetrator actually did it. Unless or until that happens, out there, Rose McGowan and you others, I would keep my mouth shut and go on about my own business and stay out of the matter. Thank you.